Gas Regulation Act 1920, 10 and 11 George V, C28. Section 1, subsection 1. The Board of Trade may, on the application of any gas undertakers, by order, provide for the repeal of any enactment or other provisions requiring the undertakers to supply gas of any particular illuminating or calorific value, and for substituting power to charge for thermal units supplied in the form of gas. 2. An order under this section may provide for modifying the statutory or other provisions affecting the charges which may be made by the undertakers, by substituting for the standard or maximum price authorised under those provisions a standard or maximum price for each 100,000 British thermal units, in this Act referred to as a therm. Subsection 4. An order made under this section, F, shall have effect as if enacted in this Act. Section 16, subsection 1. The Board of Trade may make rules in relation to applications and other proceedings under this Act, and to the payments to be made in respect thereof, and to the publication and services of notices and the publication of advertisements, and the manner in which and the time within which representations or objections with reference to any application or other proceeding are to be made, and to the holding of inquiries in such cases as they may think it advisable, and to the costs of such inquiries, and to any other matters arising in relation to their powers and duties under this Act. 2. Any rules made in pursuance of this section shall be laid before Parliament as soon as may be after they are made, and shall have the same effect as if enacted in this Act. Section 19. Any provisions of this Act, or any order made thereunder, shall have effect in lieu of any provisions to the same effect or inconsistent therewith in any Act relating to the testing of gas measuring instruments, or in any Act or order having the force of an Act relating to an undertaking with respect to which an order has been made under this Act. Unemployment Insurance Act 1920, 10 and 11 George V, C30. Section 35, subsection 1. The Minister of Labour may make regulations for any of the purposes for which regulations may be made under this Act or the schedules thereto, and for prescribing anything which under this Act or any such schedules is to be prescribed, and also a. For permitting persons who are engaged under the same employer partly in an occupation employment in which make them employed persons within the meaning of this Act, and partly in some other occupation to be treated, with the consent of the employer for the purposes of this Act, as if they were wholly engaged in the first mentioned occupation, and b. For prescribing the evidence to be required as to the fulfilment of the conditions and the absence of the disqualifications for receiving or continuing to receive unemployment benefit, and for that purpose requiring the attendance of insured contributors at such offices or places and at such times as may be required, and requiring employers to answer inquiries relating to any matters on which the fulfilment of the conditions on the absence of the disqualifications depends. C. For prescribing the manner in which claims for unemployment benefit may be made, the procedure to be followed on the consideration and examination of claims and questions to be considered and determined by the Minister, umpire, insurance officers and courts of referees, and the mode in which any question may be raised as to the continuance, in the case of a person in receipt of unemployed benefit, of the benefit, and d. For making provision with respect to the appointment of persons to act in the place of the umpire or any deputy umpire in the case of the unavoidable absence or incapacity of the umpire or any deputy umpire, and e. With respect to the payment of contributions and benefits during any period intervening between any application for the determination of any question or any claim for benefit and the final determination of the question or claim, and f. For providing in the case of any persons who are insured at the commencement of this Act under the enactments repealed by this Act for the transition from the provisions of those Acts to the provisions of this Act, and g. Generally for carrying this Act into effect. Subsection 3. All regulations made under this Act shall be laid before each House of Parliament as soon as may be after they are made, and if an address is presented to His Majesty by either House of Parliament within the next subsequent 20 days on which that House has sat next after any regulation is laid before it, after any such regulation is laid before it, praying that the regulation may be annulled, it shall thenceforth be void, but without prejudice to the validity of anything previously done thereunder, or to the making of any new regulation. 4. Any regulations made under this Act shall have effect as if enacted in this Act. 5. Section 1 of the Rules Publication Act 1893, which required notices to be given of a proposal to make statutory rules, shall not apply to any regulations made under this Act. Section 45. If any difficulty arises with respect to the constitution of special or supplementary schemes or otherwise in any manner whatsoever in bringing this Act into operation, the Minister, with the consent of the Treasury, may by order do anything which appears to him necessary or expedient for the constitution of such schemes or for otherwise bringing this Act into operation, and any such order may modify the provisions of this Act so far as may appear necessary or expedient for carrying the order into effect, provided that the Minister shall not exercise the powers conferred by this section after 1 year from the commencement of this Act. Roads Act 1920, 10 and 11 George V, c. 72, Section 9, subsection 1. If any person, being a manufacturer or dealer in vehicles, makes, in the prescribed manner, an application in that behalf to the council of the county in which his business premises are situate, that he may be entitled, in lieu of taking out a licence for each vehicle kept by him at the appropriate rate of duty chargeable under the second schedule to the Finance Act 1920, to take out a general licence in respect of all vehicles used by him, the council may, subject to the prescribed conditions, issue to him such a licence on payment of duty at the yearly rate of £10, or, in the case of a licence to be used only on vehicles chargeable with duty under paragraph 1 or paragraph 2 of the said schedule, at the yearly rate of 30 shillings. Subsection 3. If any person is aggrieved by the refusal of a council to issue a general licence under this section, he may appeal to the Minister of Transport, and the Minister shall, on any such appeal, make such order in the matter as he thinks just, and the council shall comply with any order so made. An order made by the Minister under this provision shall be final and not subject to appeal to any court, and shall, on the application of the Minister, be enforceable by writ of mandamus. Section 10. Where any persons are, whether by virtue of any act or otherwise, liable to pay any sums by way of mileage charges or other annual payments in respect of the use of any road by their vehicles, the Minister may, on an application by those persons in that behalf, and after considering any objections made by any person interested, suspend, modify, or determine the liability to make the payment, as he shall think fit. Section 12, subsection 1. The Minister may make regulations generally for the purpose of carrying this Act into effect, and, in particular, without prejudice to the generality of the foregoing provision, may make regulations, a. with respect to the registration of vehicles, and b. requiring county councils to make the prescribed returns with respect to vehicles registered with them, and for making any particulars contained in the register available for use by the prescribed persons, and c. prescribing the size, shape, and character of the identification marks or the signs to be fixed on any vehicle, and the manner in which those marks or signs are to be displayed and rendered easily distinguishable, whether by night or by day, and d. requiring any person to whom any vehicle is sold or disposed of to furnish the prescribed particulars in the prescribed manner, and e. providing for the issue of registration books in respect of the registration of any vehicle, and for the surrender and production and the inspection by the prescribed persons of any books so issued, and for the issue of new registration books and new licences in the place of any such books or licences which may be lost or destroyed, and for the fee, not exceeding 5 shillings, to be paid on the issue of a new registration book or licence, and f. prescribing the form of and the particulars to be included in the register with respect to vehicles for which a general licence has been taken out by a manufacturer or dealer, and the identification marks to be carried by any such vehicle, and defining the purposes for which the holder of a general licence may use a vehicle or a road, and g. extending any provisions as to registration and provisions incidental to any such provisions to any vehicles in respect of which duty under Section 13 of the Finance Act 1920 is not payable, including vehicles belonging to the Crown, and for providing for the identification of any such vehicle, and h. prescribing any matter which is to be prescribed under this Act. Subsection 2. Every regulation made under this Act shall be laid before each House of Parliament as soon as may be after it is made, and, if an address is presented to His Majesty within 21 days on which that House has sat next after any such regulation is laid before it, praying that the regulation may be annulled, His Majesty in Council may annul the regulation, and it shall thenceforth be void, but without prejudice to the validity of anything previously done thereunder. Subsection 3. County councils shall comply with any regulations so made by the Minister under this Act. 4. If any person acts in contravention of, or fails to comply with, any regulations made under this Act, he shall for each offence be liable on summary conviction to a penalty not exceeding £20. Section 14, subsection 3. Where, upon application for a licence to ply for hire with an omnibus, the licensing authority either refuses to grant a licence or grants a licence subject to conditions, in either case the applicant shall have a right of appeal to the Minister of Transport from the decision of the licensing authority, and the Minister shall have power to make such order thereon as he thinks fit, and such order shall be binding upon the licensing authority. An order made by the Minister under this subsection shall be final, and not subject to appeal to any court, and shall, on the application of the Minister, be enforceable by writ of mandamus. For the purpose of this subsection, the expression omnibus includes every omnibus, charabanc, wagonette, brake, stagecoach, or other carriage plying for hire or used to carry passengers at separate fares. Celluloid and Cinematograph Film Act 1922, 12 and 13 George V c. 35. Section 1, subsection 4, the Secretary of State may, by order made in accordance with the provisions contained in the second schedule to this Act, a. make regulations with respect to the use of any cinematograph or similar apparatus upon any premises used for any purpose to which this Act applies, and b. modify or add to the regulations set out in the first schedule to this Act, and those regulations shall thereupon have effect as so modified or added to. An order made under this section may apply either generally or to such classes or descriptions of premises as may be mentioned in the order. Electricity Supply Act 1922, 12 and 13 George V c. 46. Section 14, subsection 1. The Electricity Commissioners, by an order establishing a joint electricity authority or a special order, may, as regards any undertaking or part of an undertaking of any authorised undertakers, suspend any powers of a joint electricity authority or the London County Council or any local authority relating to the purchase of such undertaking or part thereof for such period and on such conditions, if any, as the Electricity Commissioners may think fit, and may for that purpose amend the provisions of any act or order relating to such undertaking, provided that no such powers shall be suspended under the provisions of this section except with the consent of the authority or authorities in whom the said powers are vested. Subsection 2. Where, under the powers of this section, the Electricity Commissioners suspend any powers of purchase relating to the undertaking of any authorised undertakers or any part thereof, they may make provision as to the relation between the prices which may be charged for electricity and the dividends to be paid by such undertakers. Salmon and Freshwater Fisheries Act 1923, 13 and 14 George V c. 16, Section 16, subsection 3. Where a fishery board proposed to purchase an obstruction or fishery compulsorily under this section, the fishery board may, subject to the provisions of Part 1 of the first schedule to this Act, submit to the Minister of Agriculture and Fisheries an order putting in force as respects the obstruction or fishery specified in the order the provisions of the Land Clauses Acts with respect to the purchase and taking of land otherwise than by agreement. Subsection 4. Where a fishery board proposed to hire an obstruction or fishery compulsorily, the fishery board may submit to the Minister an order for the compulsory hiring of the obstruction or fishery specified in the order for a period not less than 14 nor more than 35 years, and the provisions of Part 1 of the first schedule to this Act shall apply to the order in like manner as it applies to an order for compulsory purchase, with the substitution of hiring for purchase, and with the modifications set out in Part 2 of that schedule. Subsection 5. An order under this section shall be of no force unless and until it is confirmed by the Minister, and the Minister may, subject to the provisions of the first schedule to this Act, confirm the order either without modification or subject to such modifications as he thinks fit, and an order when so confirmed shall become final and have effect as if enacted in this Act, and the confirmation by the Minister shall be conclusive evidence that the requirements of this Act have been complied with, and that the order has been duly made and is within the powers of this Act, provided that, when the order relates to a dam constructed under any Act of Parliament, the order shall be provisional only and shall not have effect unless and until it is confirmed by Parliament.